Good evening, Dean, and good evening, classmates. My report for today are in Chapter 4, stated a legal and judicial bonds, in Article 2082, Article 2083, and Article 2084. What is legal and judicial bonds? Judicial bonds, also known as litigation bonds, are used when entering into civil proceeding. The purpose of judicial bonds is to ensure that you can pay the cost in relation to the legal action. If you are involved in lawsuit, you may need a judicial bonds. This is a type of surety bonds, or more specifically, a court bonds. A surety bonds is a kind of insurance. Its purpose is to guarantee you will follow through all your obligations. Before entering into civil proceeding, the court might require you to obtain judicial bonds to ensure that you can pay the cost related to the legal action. If you are required to get a judicial bonds, the court will let you know. Type of judicial bonds. Judicial bonds can be divided into two categories: defendant bonds, plaintiff bonds. Defendant bonds block a plaintiff's action or purpose payment of a judgment. They generally permit the defendant to regain control of contest property or postpone the enforcement of a decree affecting rights to property. Common types of defendant bonds are bail bonds, appeal bonds, counter-repriving bonds, and release to lane bonds. Plaintiff bonds are required of plaintiffs to ensure protection of the defendants should the plaintiff lose the lawsuit. They hold the plaintiffs liable for any damages that the defendant suffers due to the result of the court proceeding. Common types of plaintiff bonds are attachment bonds, claim and delivery bonds, indemnity to sheriff bonds, and injunction bonds and repriving bonds. And how to get a judicial bonds? To get a judicial bonds, you need to contact a surety bonds company to make sure that you are financially able and trustworthy. The surety bonds company will also ask questions about your personal and financial history. You will likely need to have a good credit history and references. If you can get a surety bonds, the total amount of the bond will likely be set by the court. To secure your bond, you will pay a percentage of this amount called the bond premium. Because of the hazardous nature of judicial bonds, you might also need to pay full collateral in addition to the bond premium. In Article 2082, the bondsman who is to be offered in virtue of a provision of law or of a judicial order shall have the qualification prescribed in Article 2056 in special laws. Article 2056 is stated that one who is obliged to furnish a guarantor shall present a person who possesses integrity, capacity to bind himself, and sufficient property to answer for the obligation which he guarantees. The guarantor shall be subject to the jurisdiction of the court of the place where this obligation is to be complied with. The qualification of a guarantor are integrity at the time of perfection, capacity to bind at the time of perfection, sufficient property to answer for the obligation which he guarantees at the time of perfection, excluding his own property, excluding his own properties that may be out of reach or which are under litigation. Note, the creditor can naturally waive the requirements for the right in general is waivable. In Rule 114, Section 9, in Revised Rules of Court, in Section 1, bail is the security given by the release of a person in custody of the law, furnished by him or a bondsman, conditions upon his appearance before any court, as required under the condition hereafter specified. Bail may be given in the form or corporate surety, property bonds, cash deposit, and recognizance. Bail is a set amount of money. There are 7 of common types of judicial bonds, include bail bonds, appeal bonds, counter-repriving bonds, attachment bonds, indemnity sheriff bonds, and repriving bonds. Bail bonds. A bail is a type of surety bonds provided by a surety bonds company through a bail agent or bail bondsman that secure the release of a defendant from jail. There are 2 types of bail bonds: the criminal bonds and civil bonds. Civil bail bonds. Okay. First, criminal bonds used in criminal cases and guarantees that a defendant appear for trial when called upon the court, and guarantees payment for any fines or penalties that are decided against the defendant. And the second is civil bail bonds, used in civil cases and guarantees the payment of debt plus interest and cost assessed against the defendant. Bail is the release from custody pending criminal trial of an accused person. A person can be released on bail at any point after being arrested. The majority of decisions about granting bail before trial at 3 points. First, when a suspect has been arrested by the police but the evidence is not sufficient for charges to be made. Second, a suspect has been arrested and charged with an offense. A third, when the court has decided to adjourn the hearing of a case to another date. All decisions on whether to grant bail conditionally or unconditionally therefore involve delicate questions of balancing interest. A person is presumed innocent of a criminal charge unless proven guilty. This implies that no one should ever be detained unless he has been guilty. He has been found guilty. Second, appeal bonds. An appeal bonds is an amount of money placed in holding while an appeal is being decided. An appeal bonds, excuse me. Appeal bonds, an appeal bonds is an amount of money placed in holding while an appeal is being decided. An appeal bonds is supplied by the appellant who is appealing the lower court's judgment and is usually in the amount of the original judgment, though it could be more. An appeal bonds is also referred to as a super dias bond when a defendant loses in court. They might choose to appeal the decision to a higher court, usually to stay execution of the judgment. When this happens, the court might require the defendant to secure a super dias bond. Third, counter-repriving bonds. A counter-repriving bonds is required by the court if a party whose assets are being repossessed decide to file a motion to stop the repossession pending a court trial in determining the current owner or the disputed assets. In counter-repriving bonds, the obligee requires the bonds to benefit the plaintiff. What documents are required to obtain a counter-repriving bonds? First, copy of complaint. Second, copy of final court order that approves the bond. Third, completed application. Fourth, financial statement, only necessary if you are attempting to get the bond approved without collateral. Fifth, if collateral is required, then collateral agreement. When will you need a counter-repriving bonds? Typically, a court may require a counter-repriving bond in civil cases involving possession of an assets or property. However, the amount of coverage in this type of bonds is usually set up to 1.5 times the value of the asset of property in questions. If the defendant fails to file a counter-repriving bonds, the court will order the release of the property to the plaintiff after posting repriving bonds. A counter-repriving bonds provides protection to both the plaintiff and the defendant pending the final resolution of the lawsuits. But while the accused will be allowed to retain possession of the property, he or she will be held responsible by the court to cover all costs and damages. The counter-repriving bonds safeguard the plaintiffs during the time the case is being litigated. Additionally, it also benefits the defendants because it allows them to retain control of the assets. And the defendant is obligated to compensate the plaintiff for all the costs and damages on the property should the court rules in plaintiff's favor. The defendant is mandated to release the property to the plaintiff in the same condition as when it was recovered. Parties involved in counter-repriving bonds. Like all surety bonds, there are three parties involved in counter-repriving bonds: principal, obligee, and surety. The principal, the dependent of the parties seeking a counter-repriving bond, a repriving action to regain possession of a reprived property. The defendant guarantees to release the property if the case is ultimately ruled for the plaintiff. The obligee, the court which requires the bond to benefit the plaintiff. The obligee is also often called the beneficiary party. Surety, the bonding company that underwrites and issue the bonds. Example of counter-repriving bonds. Anna and Carlos have decided to terminate their marriage of 10 years through a divorce. However, when Carlos moved out of their apartment, he was unable to get his electronic gadgets, particularly his 17 inches smart television. But Anna refused to give him the TV, insisting that she owns it. Before filing a lawsuit before a court, Carlos obtained repriving bonds from a surety that allowed him to get to take possession of the TV. Upon releasing the TV to Carlos, Anna then obtained a counter-repriving bond from a surety company that allowed him to regain possession of the television. Fourth, attachment bond. An attachment bond is a surety bond which guarantees the full cost and damages associated with an attachment proceeding. In the event the court rules the attachment to be wrongful, these surety bonds protect the defendants against a loss. The bond's amount varies by state, but usually includes a provision for interest of court cost. When do you use an attachment bond? Before an attachment bonds or before an attachment of property can proceed, the plaintiff must cover the action with a surety bonds. This means a bonds will be used before a judgment is made. The attachment bond protect the defendant against a financial loss should the court later ruled the attachment was wrongful. How can an attachment be wrongful? There are different circumstances where an attachment can be deemed wrongful by a court. Only certain types of property can be attached. So if the plaintiff is outside these guidelines, the attachment is wrongful, and the surety bonds will cover the damage. Another situation may be if the property is located outside the jurisdiction of the bond. For example, a Manila attachment bond can only be used for property in Manila. These scenarios are others with you before writing the bonds. Why are injunction bonds necessary? If the court finds that the injunction was issued in bad faith, the plaintiff bond will cover any damages that the defendant may sustain. The surety bonds cost varies by state, by usually includes and provision for interest and court costs. What is indemnity to sheriff bonds? A sheriff indemnity bonds is surety bonds that protects a law enforcement agency seizing property on behalf of a plaintiff from defendant. Should the defendant seek damages against the enforcement agency? How much is the surety bonds cost? The cost of sheriff indemnity bonds varies stated by the state, but usually include a provision for interest and court costs. It is imperative that the sheriff indemnity bond cover the full value of the property by being seized. You can contact agencies to discuss the specific of your bond's requirements. What is an injunction bonds? An injunction bonds is a type of surety bonds that covers any damages the defendant may sustain should the court rule the plaintiff's suit is wrongful, thus protecting the defendant from being wrongfully enjoined. In Section 9, amount of bail guidelines. The judge who issued the warrant or granted the application shall fix a reasonable amount of bail, considering primarily but not limited to the following factors. Financial ability to the accused to give bail, nature and circumstances of the offense, penalty for the offense charged, character and reputation of the accused, age and health of the accused, weight of the evidence against the accused, probability of the accused appearing at the trial, forfeitures of other bail. In Article 83, if the person bound to give a bond in the cases of the preceding article should not be able to do so, a pledge or mortgage considered sufficient to cover his obligation shall be admitted thereof. Rule: if the bond is not given, note that instead of the bond, a pledge or a mortgage may be made. In Article 2084, a judicial bondsman cannot demand the exhaustion of the property of the principal debitor. A subsurety in the same case cannot demand the exhaustion of the property of the debitor of the surety. A. No right to execution. A judicial bondsman being a surety is not entitled to the benefit of execution granted a guarantor. The benefit is also defined as a subsurety. B. The ability of the surety if creditor was negligent in collecting. A surety is still liable even if the creditor was negligent in collecting from the debitor. As stated in American jurisprudence, the contract of suretyship is not that the obligee will see that the principal pays the debt or fulfills the contract, but that the surety will see the principal pay or perform. C. Effect of violation by creditor of terms of the surety agreement. A violation by the creditor of the terms of the surety agreement entitles the surety to be released therefrom. However, where an assurance company has profited in the issuance of the bond, which it had furnished for a premium of the mere allegation or ground that the release of a prisoner was unauthorized under the provision of law. Letter D. Bonds filed for alien stay. Excuse me. If a surety bonds filed for an alien stay in the country is profited because of the violation of its conditions, its subsequent authorized cancellation through mistake or fraud does not relieve the surety. A bond surrendered through mistake or fraud may therefore be considered as valid and subsisting instrument. A. Rule when performance is rendered impossible, even when a surety performance of the bonds is rendered impossible by an act of God or of the obligee or of the law. It is the surety's duty to inform the court of the happening of the event so that it may take action or decree in the discharge of the surety. Thus, if the surety took no such steps, it is equally chargeable with negligence in this connection. If obligation of surety to keep the accused under his surveillance, it is will settle that surety is the jailer of the accused and is responsible for the latter's custody. Therefore, it is not merely his right but his obligation to keep the accused at all times under his surveillance. A trial court has no authority to relieve the bonding company from a part of its liability under the bail bonds by ordering the mere trial confiscation of the bond, where the body of its principal has not been surrendered to the court despite several extension of times granted said company to produce him. For it is the bonding company's responsibility to produce the accused before the court whenever required. The failure to do so is indisputably complete breach of the guarantee. However, if 3 days after the forfeiture of the bond, the accused immediately submitted to the jurisdiction of the court, giving witty reason for his failure to appear, the amount to be forfeited really may be reduced to certain degree. In the case of Philippine National Bank versus Luzon Charity Corporation Incorporated and the Court of Appeals. The facts of the case. Defendant Augusto R. Villarosa, a sugar planter, adhered to respondent Lopez Sugar Central Milling Company Incorporated, applied for a crop loan with petitioner Philippine National Bank. This application was approved in the amount of 32,400. Villarosa executed a chattel mortgage on standing crops to guarantee the crop loan. In considering periodical sums of money by him received from PNB, planter Villarosa executed these promissory notes, from which will be seen that the credit line was that the original amount of 32,400 and was thus maintained, but afterwards it was increased, and so the other promissory notes were based on the increased credit line. Hence, there are a balance of 63,222.78. Consequently, as of the date when the complaint was filed because of the interest accrued it has reached a much higher sum. Due to its non-payment, PNB filed the complaint seeking relief not only against the Villarosa, but also against the three bondsmen, Luzon Surety, Central Surety, and Associated Surety. Luzon Surety has filed the bond in the sum of 100 of the sum of 10,000 Central Surety and the sum of 20,000, and Associated Surety the bond in the sum of 15,000. Excuse me. In the obligation of the bondsman being to guarantee the faithful performance of the obligation of Villarosa with PNB. Each of the dependents in the answer raised various defenses. But as far as principal dependent Villarosa and other dependent Central Surety and Associated Surety are concerned, their liability is no longer material because they have no appeal. The subject of contention is the liability of Luzon Surety as one of Villarosa's bondsmen. Luzon Surety contended that the evidence of the PNB did not establish a cause of action to make Luzon Surety liable, and in any case that there had been material alteration in the principal obligation, if any, guaranteed by it. The trial court ruled in PNB favor, holding Luzon Surety jointly and severally liable with Villarosa. However, the Court of Appeals reversed the trial court's decision, absolving Luzon Surety of any liability, hence this petition before the court. The issue whether or not Luzon Surety is liable not only as guarantor but also as surety. And the ruling, the surety bonds executed by Luzon Surety covers the chattel mortgage executed by Villarosa in favor of PNB. The unrefuted testimony of PNB witnessed that the chattel mortgage was the only contract executed by Villarosa, evidencing the crop loan contract upon which the Luzon Surety agreed to assume liability up to the amount of 10,000 by posting the said surety bond that a judicial bondsman cannot demand the exhaustion of the property of the principal debtor. Hence, despite of the execution of the chattel mortgage by the debtor on his obligation, the surety is not entitled to the benefit of execution because he is not a mere guarantor, but surety whose liability is the primary and solitary. Thank you and have a good day.